call this meeting to order. This is the Tennessee State Board of Accountancy. Today is May the 5th, 2017. The meeting has been properly noticed, and copies of the agendas were posted to the website on April the 27th, 2017. Could we have a roll call for attendance, please?
Pamela Church. Jerry Watkins.
Here.
Casey Stewart.
Here.
Don Royston.
Here.
Stephen Eldridge.
Here.
Janet Booker Davis. Here. Gay Moon. Here. Larry Elmore.
Here.
Kevin Monroe.
Here. Thank you. We have a quorum. Form of announcements. The board will be represented today by our attorneys Liz Goldstein, Sarah Page, and Matt Reddish will assist with the legal reports. In your folders, the little red folders you have here, there is a new authorization to authorize Laura to process your travel authorizations for you and travel claims. You previously signed one for Karen. This will give a little backup and realigning of some duties, so please be sure and sign those in addition today. Members, please remember to not talk over people today and to speak into the microphones for the recording process. At this time, we'll have approval of the minutes. There's two sets of minutes, and I'll take them individually that will be presented to you. The minutes of the January the 20th regular meeting are on your iPads. You were previously furnished copies of them for review. Are there any additions or corrections to the January the 20th, 2017 minutes? I would entertain a motion for approval.
So moved.
Second. Have a motion and a second. All in favor say aye.
Aye.
Opposed, like sign. Motion carries. We had a special called telephonic meeting on April the 20th, 2017. Those minutes are also presented in your packets and were previously mailed to you for review. Are there any additions or corrections to the April the 20th, 2017 minutes? Hearing none, I'd entertain a motion for approval.
So moved.
Have a motion and a second. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Wendy Garvin, our Executive Director, would you give us your executive report, please?
Sure. This is on your iPads, listed as Director's Report. As we do at each one of these, I've got your future meeting dates as well as the next proposed date on here. I know in the past you all have given some interest in moving from a Thursday, Friday to some other day a week. So anytime you want to propose something different, feel free to let me know if you'd like to try a Monday, Tuesday, or something different. We can do that. In the next section, I talk about NASBA meetings, activities, the exam fees. The implementation of the 2018 exam fees have been released, and those will take effect for our jurisdiction on October 21st. There's a letter as an attachment to this director's report that further explains why that date is picked. It has to do with how long our notice to schedule lasts, etc. So if you have any questions about that, let me know. This is, I know some of the fees have increased because of the new exam, additional testing time, etc. The NASBA Conference for Executive Directors and Legal Counsel was held in March in New Orleans. Liz and I attended that conference, as well as there were CEOs from 27 state societies, so that meeting is typically kind of a joint meeting, at least for the first half of the meeting, so that we can network with those at the state society, and we have sessions that are of common interest to both of us. So some of the topics that we were talked about during those sessions were the CPA pipeline, the evolution of peer review administration, legislation that's affecting the profession, updates on accreditation, and of course updates on the new exam and some NASBA technology issues. The upcoming NASBA meetings, NASBA is holding their regional meetings in June. There's the Western at the beginning of June in Idaho and the Eastern at the end of June in Rhode Island. Don Royston and Larry Elmore will be attending the Eastern region. And then the annual meeting is at the end of October this year in New York City. I currently have Janet is interested. The next item on here is just kind of for your information, and if you would like this on a future agenda, you all can let me know. CPA's marijuana and moral character. So as you know, many states have approved the use of marijuana in certain facets in their state, and while that hasn't been approved in Tennessee, as you know, people operate and hire CPAs from all over the country. So we have had, I think, 2 calls from individuals interested in whether performing services for a marijuana-based company would be any kind of violation in Tennessee. And so the AICPA has directed them to state boards. Well, this board has not discussed that or taken a position. So it's something to think about. I attached, I believe in attachment 2 here, I attached some statements that some other boards, they've discussed and they have put out a statement. In general, simply servicing an organization that distributes marijuana, most states don't consider that an acts discreditable. However, they still indicate that they have full authority should there be any other issues that come about of taking action on such individuals or firms. So, like I said, we haven't had a ton of interest because it's not legal here in Tennessee, but people operate all over the country, so something to think about. Exposure drafts. There's an exposure draft out on the model rules, and it really addresses CPE. This was released in February, and the comments are due June 30. We can certainly, I did not bring this for a full discussion to determine whether we wanted to comment because we already incorporate all of these items in our rules. Fields of study are technical and non-technical. We have talked about that part of it. But we already have a technical requirement in our rules. A lot of states don't have a technical requirement in their rules, and that was added to the model rules. And some of the other suggestions in this exposure draft is 50% of total CPE credits should be in technical fields. We already have that. Recommends that CPE that averages no fewer than 40 credits, including 2 credits of ethics in each annual period. We are slightly off from that. We require minimum 20 per period, but ultimately you need 80 hours. And then the last item is recommends that the compliance with CPE standards be required of all providers, including AICPA, state societies, members of the National Registry, associations, or any groups recognized by the Board of Accountancy. So we really already have that stated in our rules. So on to the next item, the NASBA jurisdiction reports in attachment 3. These are just consolidated reports that come out each quarter on the exam pass rates in our state versus other states. Something I noted in here was that our pass rate still remains fairly consistent. We are usually anywhere from 49.6 to 50.1% pass rate in Tennessee. So we have had an uptick, as we would have expected, in the number of candidates because a lot of people were trying to sit in advance of the release of the new exam. So I think that was expected across the board. So there's a lot of statistics there. I try to provide it so that you all can take a look, and if you have any comments, to let me know. TSCPA activities. I did attend a couple of chapter meetings with the TSCPA, the Nashville chapter meeting in February, as well as the Elk Valley chapter meeting last week. That was a student meeting, so we did talk about the exam. And I also attended the TSCPA Board of Directors meeting last Friday. Continuing education. We have become aware that the AICPA and probably others are issuing credit in half credit increments. So they would issue a certificate that says 0.5 credits. So this, of course, is an issue for our licensees because our rules state that you have to obtain 1 full credit before you can receive partial credit. So we would not accept nano learning or any half credit hours. So your certificate should always say 1 point something or 2 point something. So we had a case recently where an individual wanted to reinstate their license, and we had to discredit a huge number of the hours that she was using to reinstate her license because she had a lot of half credit hours by the AICPA. So we did address this in our newsletter in the fall, mainly addressing nano learning, because we did not realize that this was very prevalent. And then we had this issue, and I think we've had one other issue. So we will address it again in our newsletter. That'll go out in a couple of weeks. We may do a standalone email if we see some more of it during the audit, just to kind of put it in people's faces. I've talked about it at any events I've gone to. I've tried to share with folks to spread the word that as of now, you have to have 50 minutes before you can have partial credit. So if this board wants to reconsider our rule and drop that down and allow some half credits, we can certainly do that. I did address that at a previous meeting, and we decided we would wait for model rules to be approved, so whatever wording we used would be consistent across the country. So that's kind of where we stand on that.
Do they have that model?
It's not quite ready yet. So that's in that rule package, or that exposure draft. I believe, now that I think about it, I'm not sure I read that. I'll check into that. I know it's not ready yet, but I don't know if it's in that or it's still to come after that. So something to be aware of. As far as the CPE audit, we just started that process and mailed out audit notification letters early last week. You all probably received those. But a little bit new process this year to help for tracking purposes of that audit. So we will let you know there were 531 individuals selected for audit, and that represents 10% of the licensees. The next page gives you just our renewal statistics from 12/31/16 on how many folks have renewed, how many are still in expired grace. That was as of April 19th that we pulled these numbers. Then I list new licenses issued, and typically I just give you a number, but I thought it was interesting. The new licenses that we issued in the first quarter of 17 is far less than the first quarter of 16. And so I'm just kind of looking for a trend and why that may be. I expected more with the people rushing to take the exam, trying to finish it up. So I was a little surprised to see that number. So we'll just keep an eye on that and see if we can come up with any reason why. And then the last part of it just gives you our general statistics. The good news is our active licenses numbers continue to increase little by little, so we're not seeing a drop there. That concludes my director's report.
Thank you, Wendy. Excellent report. Do we have any questions for Wendy on her report? Hearing none, our next item of business is a reinstatement application for Teresa Joy Wilder. I believe the plan is, as in the past, is that we basically look at it and see if it's a complete application, and then it's on the agenda for the next meeting for action. Is that
Correct.
correct? Okay. Wendy, would you like to present that, please?
Sure. All right. I believe you all assessed discipline against Ms. Wilder back in the October 2016 meeting. And what I'm going to do is I'm going to go to the consent order that she signed, and I'm just going to give you a rundown of what her violations were. And then I'll tell you what's happened since then that's caused the license to be revoked, okay? So in the consent order, the stipulated findings in fact are as follows. Respondent holds a Tennessee CPA firm permit. number 1593. Respondent's firm permit expired 12/31/15 and was not renewed until April 3rd of 16. Respondent conducted and issued an audit while respondent's firm permit was expired. Respondent began work on the audit from the above paragraph 3 in this section before having an approved contract from the Tennessee Comptroller's Office. Respondent holds an individual Tennessee CPA license number 12026. Respondent's CPA license expired 12/31/14 and was not renewed until February 24th, 15. On respondent's CPA renewal form, respondent answered yes to the question regarding the renewal applicant being compliant with 80 hours of continuing education for the previous licensing period. In the respondent's answer to the peer review committee, respondent stated being deficient by 40.5 hours for the licensing period 13-14. So those are the findings of fact in the consent order. She signed that consent order and submitted it with a sticky note saying, I'm sorry, let me go down and read you what the order was. I apologize. Okay, so the pursuant to the Act and to the rules promulgated thereunder, to the following disciplinary action is hereby imposed on the respondent, T. Joy Wilder. Respondent firm shall pay a civil penalty of $1,500 and comply with professional standards and $1,000 for failure to comply with professional standards and $500 for issuing an audit report on an expired firm permit. The same to be remitted together with a signed copy of this order. Respondent's personal CPA license should undergo a mandatory CPE audit for the CPE periods 13-14 and 15-16 to ensure compliance with the requisite minimum 80 hours of CPE per licensure period. Respondent understands, acknowledges, and agrees that once the respondent has signed this order, failure to timely complete with any terms contained in the order shall result in automatic revocation of the respondent's CPA firm permit without the necessity of a formal hearing based on the admitted violations set forth in this order, and that such revocation would not relieve respondent of the requirement to pay any remaining balance of the civil penalty. Okay, so after signing this, she submitted it with a sticky note indicating she would pay the following week. So the date that she signed this order was 12/27 of 16. It was fully executed by legal and myself on December 30th of 16. So now what comes? Okay, and she indicated that she would pay the following week. So we assume we're going to get payment around the first part of January. So on January 27th, it's evident she has not paid yet. So we sent her what I believe legal calls a demand letter requesting payment. So that letter you would find in page 18 of your document. And that letter basically advises her we have not received the $1,500 civil payment from her executed consent order, and that we request to be paid immediately. If not paid by February 10th of 17, that her license would be revoked, and that this is her final notice. We did not receive that payment by the February 10th, so ultimately we sent a letter to her advising her that her license had been revoked for non-payment of the civil penalty. Subsequently, she submitted payment. Because her license had been revoked, we can't just simply undo it since she then paid. So we explained the process of a reinstatement application. So she has completed a reinstatement application for her individual and firm permit and paid the $1,500 civil penalty and the reinstatement application fee for both the individual and the firm permit application. And we are here today to look over this to see if it's complete. She also submitted CPE to comply with the 13-14 period. We have reviewed that and it does comply with our requirements. So I believe that she has submitted everything and has a complete application. So I think the decision for the board is, do you agree with that recommendation? Would you like her to be present at the next meeting? Or would you simply want to consider her application at that time for reinstatement?
Question from Wendy.
I had two questions. After the demand letter was sent, did she notify us or contact us or just stayed silent?
Silent.
Did she give any reason why she was late after the fact, or did she just ignore it, basically act like nothing happened and sent the check in?
I think ultimately, either when she sent the check in or when she submitted the application, she said she had been sick.
Specify sick like a cold or sick like I'm in the hospital?
I think it was just a traditional, she was sick for a week, is what I recall.
How long after did she submit the payment? You told us the dates, February 10th, if she didn't submit the payment, but when was the payment actually submitted?
Got it too. Gosh, I can't see. It's so small. I know. March 2nd is when we entered the payment.
Refresh my memory, what's the process then for reinstatement? She's filled out the application for reinstatement. Is it a fine or a fee or?
There's a $250 fee with the reinstatement application, so she has submitted that for both the firm and the individual, because both licenses were revoked. And your duty today is to approve the complete application or tell me if you want something additional. And then at the next meeting, you will consider whether to reinstate her license. And you can have her, ask her to be present or not.
So basically, if somebody doesn't follow through on the agreement we make with them, and then they ignore our demand letter, then regardless if they pay a day after or a year after or whatever it is, this is the same process for all. There's no punishment other than you're paying a reinstatement fee of $250. I mean, I guess maybe I'm taking this too personally, but I just disregard for us, going through our processes or policies of getting someone in good standing and they agree to it, and then we spend a lot of time getting to those consent orders and whatever agreements we have, and they just disregard it and don't follow through. I just take exception to that personally. We've never had an issue with this individual before.
No, I don't believe there's any previous complaint
history.
No other extenuating circumstances. The week's illness is pretty much the
That's all I'm aware of.
I'm sure the frustration with not following through on the consent order and the payment, but at the same time, then subsequent to her not following through, we did take action and we did revoke her permits. And so now she has to go through this reinstatement process. I'm not sure. I think the board acted appropriately to follow through on the revocation. And I guess I'm kind of sitting there saying, well, we are where we are now. She has gone through the hoops that it takes to reinstate. I'm struggling to find a basis to not accept that, I guess is where I'm kind of thinking.
That is my thought. I mean, I think she was certainly delinquent, and maybe we should consider if there's, in our consent orders, if they don't follow through, there's an additional penalty, or the reinstatement fee for your revoked license, maybe we should increase that or something in some other, proposed policy or rule change. But I mean, I think our role is to make sure that the public interest is the public is not harmed. I don't think that's the case. I think it's probably a case of her getting busy and life happening, and she was late, but she did have to jump through additional hoops to do this, and she has completed that. And
I would say instead of us guessing as to why she did what she did, I would just recommend that we bring her in and just have her explain why she didn't pay it on time. I mean, we have a valid application, it sounds like, from staff. I think that's all they're asking us to approve today. The question is whether or not we want her to appear or not appear. And I would think in this situation, she didn't comply with the consent order. Let's make her go through the process of coming here and explaining why she decided that wasn't necessary.
I agree. I wasn't trying to say that I didn't agree with this application. I'm just saying, in general, the process of this doesn't seem to be severe enough for someone just to disregard a consent order. There's a lot of effort that goes into that, and simply I was sick or life was busy, everybody's busy. You know, I think that at least a phone call to say, hey, I was here. I'm just saying in general that may be something we want to consider going forward.
I think those are appropriate questions to ask her if we make her come in. I think we can just ask her, why did you not do this?
Was there a time frame around the expectation for when we were expecting her to respond to?
I think there were 2 time frames.
When you sign a consent order, it's stated in there that the civil penalty would come with that signed consent order, and that's what happens in 99% of the cases. So, or if somebody is unable to pay, I believe they contact the legal division and they can work out a payment plan, but then we redo the consent order and it specifically states in the consent order what the payment plan is that they're agreeing to. So she did not do anything except for say, I will pay next week. And we thought, okay, well, we'll give her that chance. And a month went by and we did not receive payment. And then that's when the demand letter was sent, requesting payment.
And she missed that date as well. So that's right, the 2.
Can I make a motion? I'd be happy to make a motion. That we accept the application as presented and require that, what was her name again? Miss Joy Wilder. Ms. Wilder be present at the next meeting for the reinstatement discussion. And I would second that.
I have a motion and a second on the floor. Is there further discussion? Wendy, I'd like one other question, and it may not be relevant, but is she enrolled in peer review?
Look like there are a lot of her CPUs in
She is enrolled. However, now I'm glad you brought that up because, you know, we don't have a lot of access to the details. But her, it appears that she's under corrective action for her previous peer review, and it's been a significant amount of time and it's not completed yet. And so that may be information that you would like to get from her. So as far as I can tell, a peer review was completed. She had some corrective action due almost a year ago, and I've not seen a completion letter, which is my indication that she satisfied the committee's requests.
When you, to that point, when you call her and say, hey, you've got to be present at the next meeting, you might want to say that's going to be one of the questions I ask, and maybe that'll get that.
To make that part of your original motion.
I can add that in for sure.
That would be helpful.
I think that we need to make a motion that we notify her of her requirement to attend the next board meeting, and that she also be informed that we will be asking about peer review. We expect that to be cleared up at such time.
Your second was, you accept the second, her amended motion. We have an amended motion on the floor. All in favor signify by saying aye. Aye. Like sign. Motion carries. NASMA committee reports. Mr. Elmore, you're on the audit committee of NASMA.
I really don't have a lot to report at this point because we haven't had a meeting yet, except for, well, we had one of those telephonic meetings. They call it an introductory meeting where we just kind of met each other without seeing each other. But we talked about the process, what would happen during the year. From what I understand, there'll be basically 2 face-to-face meetings, one which is next week, actually, and it's a planning meeting talking about the process, and then the main meeting will be in September after the audit report is issued that we are to approve. LBMC does their audit, and So we'll be meeting in September to approve that audit report after we go out to the meeting. So it's kind of unusual. I got a call yesterday while we were in this meeting asking me if I would serve another term when we hadn't had a meeting yet for this term. So I guess they like my work so far. Yeah, good job.
Take us to D.C. Where do you mean?
So anyway, that's basically all we've done so far is do a lot of planning and talking, but I'm excited about it. I think it'll be good to serve on that committee and learn how that process goes.
Good resume material, isn't it?
Yeah. For my second career.
Thank you for that wonderful report. Judy, have you been ethically charged?
I have been on this committee, and I'm telling you, this is a busy committee. Yes, we've had numerous, we've not had a face-to-face meeting, but we've had numerous calls, and long ones too. So, but ethics, and these people, I got to tell you, I'm extremely impressed with these people, and they really dig into the substance of these issues. The issue we're working on right now is a response to the AICPA regarding the non-compliance with laws and regulations. And basically, there are a couple, one specific committee member that has, I guess in his experience, run into a situation where there was a staff level auditor that discovered something that they felt was unethical. And as I understand it, the conduct rules kind of tell you how you step through that process where no action was taken, and basically the issue was never exposed, and there's no current way for a whistleblower that discovers something to take any action beyond that chain of command. And if the business owner that they're auditing or whatever chooses not to address the situation, there's just really no resolution process for that. So what we're currently doing is editing a lot of current, I guess, rules and regulations around that to try to make sure that we have some way for a whistleblower to at least be heard along the way, and not, because right now they would be going against the code of ethics by going beyond their typical chain of command, and something could be covered up is the issue, I think, that we're currently looking at.
You're referring to staff member out on an audit, discovers something, chain of command up his line, decides that it's not worthy of anything, and it just dies on the vine.
Right.
And that staff member then has no way to fix it or make it known.
Right. And then also, if a audit firm performs an audit and they're not the tax preparer, there's a separate firm for a tax preparer, the audit firm cannot communicate directly to that tax preparer anything that might affect. And I guess where I came in on this was, I think a lot of business owners do that on purpose because there is that wall there where unless the business owner allows that audit staff to communicate to the tax preparer something, there's protection there for that business owner where they can, cover up things, sweep things under the rug. They don't have to provide that information that went on in the audit or whatever. So I think we're trying to, just to make sure that there's more visibility between, that there's that we're not just stopping people from being able to communicate when there's something wrong.
But you're saying the committee's trying to break down that wall of separation to open up? Okay.
Yeah. If there's something,
The rule right now would be if there's two firms doing the audit and the tax return,
they can't.
they would have to go through the owner to get permission to talk to each other.
Correct.
I guess I had...
Speak into your microphones, please, so that we're getting start over.
Yeah.
My question was, so your committee is trying to break down the separation there that exists so that two firms can communicate better.
In a situation where there's something that is questionable or there's a potential problem, or the other firm, like the tax preparation firm, could be signing a tax return that the audit firm knows is incorrect. And
Right. Well, of course, the intent of the two firms in a situation like that normally is the independence factor, where the tax preparer is not involved in the tax accrual or the evaluation of the fairness of the tax accrual and so forth. So, I would think there's some degree of communication already in passing through the information from the tax accrual to the means of work paper sharing or so forth. So you probably run into this more than...
I would say either way. I mean, if I'm an auditor and I'm performing an audit, I have to attest to the validity of the tax.
Well, I guess what I'm saying is I think there's already some communication there.
It doesn't necessarily have to be. I could be doing my own accrual without even talking to the tax preparer, correct?
Yeah, but the other way around, though, if you're the tax preparer, you sort of almost have to see the tax accrual.
Or you'd have to see the audited statements or something that you'd have to see some statements that you feel are accurate to file an accurate return, right? I mean, not necessarily the tax accrual.
Yeah, I just never had thought about having to get permission from the owner to see that, but I guess you do.
Normally, that would be expected. I mean, if we were doing an audit and the owner did not give us permission, to me, that would be a red flag.
Yeah, you probably wouldn't have been forward with the engagement if they said, no way, you're not going to do that.
yeah, and
How are you attempting to deal with this? I guess that's my question.
through the wordsmithing and making some changes to what's currently there. There's a guy, and I can't remember his name right now, on the committee that has apparently experienced some of these issues. So, or he was on another committee somewhere where they had walked through this particular situation. And so, gosh, we've been talking about this and working on this since, I think, early March. So, I mean, a number of calls and letters and emails and reviewing and discussion has transpired. So we're not there yet. We're going to submit a letter to the AICPA Professional Ethics Executive Committee for them to consider some things. So that's our next task. We're working on that proposal right now.
Go ahead. No, I was just saying, is the intent to give the tax preparer or the auditor the ability to make a judgment call to contact that other accounting firm directly without the owner's knowledge or consent, or?
I don't think so. I think it would be more like...
You have to sign this form giving me authorization to do so?
Yeah, or they
so you
could...
can't accuse me of releasing something I really shouldn't have that I thought was legitimate. But
yeah, there's... I'm not really sure what the outcome on that's going to be yet, because there's a lot of discussion, and I don't think that we would get to really decide that, but we're just trying to make, I think, provision that people through the code, the ethics code, have options rather than it's just, at this, because right now it's just this point, if the business owner says no, that's no.
Biddy, I was just going to say, this issue goes way, way back. I mean, this would be a huge change, it seems to me. It's certainly not the first time it's been considered or discussed. Do you think you'll get pushback? Because that's not a little issue.
That's obvious with our, I don't even know how many people on this committee. When we're on the phone, I would say there's like almost 12 or, there's a lot of people on the call. It's hard to manage a call, in fact. I don't manage it, but of course, but just getting everyone's opinion and comments takes quite some time, but it is certainly a big deal, and that's obvious that everyone on that call, more so than me, in fact, realizes that. So they're frustrated about it too. So
yeah, with the recent changes in independence rules over the last 5 to 10 years, usually see some large corporations have 4 and 5 firms involved doing different things and unrelated to each other, and so that communication between and amongst those can either be good or not good, and so I think it's a very, very relevant topic to talk about. But if you're one of those firms and you get pushback from the owner that says, I don't want you to talk to those other firms, that's a red flag for sure. So I think that's a good return in itself.
yeah, so that's what's going on, and I'll hopefully have better notes and more information at our next meeting as to what we did. Maybe even if it's allowable, I'll find out if I could share with y'all what our proposal was.
Thank you, Judy. Moving on to our board committee reports. Mr. Larry Elmore, would you do our licensing report, please?
Yes, sir. The licensing committee met yesterday on 4 topics. The first being a registrar asking for CPE credit for studying for the Chartered Alternative Investment Analyst exam, and this would be level 2 of that exam. And quite a bit of hours put into this course and study time for this course in attempting to pass this course. And so this person has submitted the outline of the courses that he had studied for the exam for, which were provided to the committee and discussed yesterday. And after a review of the information provided, the licensing committee recommends that we approve that course as qualified for CPE credit in Tennessee.
Would you like to make that in the form of a motion?
Yes, I will make the motion that we approve the request by Justin Rickard for CPE credit for the CAIA Level 2 examination course.
Have a second on that?
I'll second that.
Ms. Wendy, I think we've got a question.
I think they're indicating that this needs to be a roll call vote, and I'm not sure if it's because Dr. Church needs to recuse herself.
We'll have a roll call vote, and let it be noted also that in this vote, we have a list of approved non-standard CPE tests and all that we maintain that are approved for CPE credit, and this is adding that particular exam to that existing list.
Correct. And disregard, it does not need to be a roll call vote, but let it be noted that Dr. Church is recusing herself.
All right. With that, is there any further discussion on the motion? All in favor signify by saying aye. Aye. Opposed, like sign. Let the record show Ms. Pamela Church recused herself.
Next, moving on, we have a very closely related request from Cyril Rager, requesting information from a course provided by the Institute of Management Accountants related to the certification in strategy and competitive analysis. And I think we're going to be seeing more and more, just as an aside information, we're going to be seeing more and more of these because there are just so many specializations these days that are coming around and popping up to ask people to pass courses and pass certifications to be specialized in a certain thing. So here again, after review of the materials that were provided by Mr. Rager, we recommend approval of this course for CPE credit in Tennessee. In a form of a motion.
Do I have a second to that?
Second.
All right. I have a motion and a second on the floor. And Lindy, would you, just for the record, tell us how the credit is awarded on that, on a course of this nature?
Yes. The rule states that approved exams are awarded at a rate of 5 times the length of each exam taken and limited to 50% of the total CPE required under Rule 0020-05-.03. Also, I apologize, I'm not sure if you all did this in the first motion, but if you could state, I think yesterday you stated this would be in the management, would be coded in management.
This one will be coded in management. Would you amend your motion, sir, or would you like to amend your motion to further clarify your motion on this one?
The first one?
No, this motion's on the floor now. We'll go back and fix the other one.
Yeah, I think the second one that we're addressing now should be under the management category, primarily because it's provided by the Institute of Management Accountants.
You're amending your motion to include that, and then second?
A second.
Okay, and we have an amended motion and a second on the floor. All in favor signify by saying aye. Aye. Opposed, like sign. We'll refer back to the original motion that we had on the first one, and the section that should be categorized under, please.
I think he said management.
I don't. For point of clarification,
I'm just taking a minute here to make sure that I do agree with its management. I would amend my motion on the first
motion, I think, or is that parliamentarian?
Can I not just amend my motion?
Yeah, just withdraw it and we'll do it again.
Okay, the original motion, I think, Mr. Elmore, you're withdrawing the original motion, and is that?
They're saying that you need to withdraw your first, and then vote to withdraw, and then do a new motion.
Okay, going back to the motion to approve Justin Ricker's request for a chartered alternative investment analyst, I'd like to withdraw that motion and restate it to say that we would...
Well, you got to withdraw first, right?
We're going to withdraw first. Okay. And we have a second to withdraw?
Vote on the second to withdraw.
Okay. All right. All in favor of withdrawing the original motion, signify by saying aye. Aye. Opposed, like sign. Motion carries.
Okay, now I'd like to make a motion to approve the request by Justin Rickard to qualify his course exam and preparation time for the Chartered Alternative Investment Analyst Exam Level 2 for credit, CPE credit in the state of Tennessee, or for the category of management.
Thank you. And we have a second. We have a second. All in favor signify by saying aye. Aye. With Pamela Church recusing herself. Thank you.
Thank you.
Okay, third topic on our committee's agenda yesterday was to discuss a state-specific ethics course that had been submitted to us for approval. And as you know, that we're in the process of evaluating all these courses and have told everyone that has a course currently in place that it would expire December of 17. This particular entity had resubmitted the course because it had expired, and we're asking for reinstatement to move forward again. And after looking at the course and after staff had looked at the course and found several exceptions to our rules that needed to be corrected. The committee recommends that this course not be approved at this time.
I make the motion that we do not approve the state-specific ethics course as submitted by Stephen Bragg, I think.
Motion on the floor.
I'll second it.
We have a second. Any discussion? All in favor signify by saying aye. Aye. Like sign. Motion carries.
Okay, the last item on our agenda was, after staff had looked at several areas of our state of Tennessee's CPE categories, they provided to us a listing of some areas that were in conflict with NASBA's categorization as to whether they were technical or not. And I'll talk about these in two groups. One group relate to NASBA, subjects that NASBA considers technical that Tennessee does not. These subjects were broker-dealers, courses, options on futures, ERISA compliance, HIPAA compliance, personal financial planning, and PCI compliance. And after discussion, the committee recommends that we change our categorization from management to technical for those courses.
Of a motion?
Yes, this is a motion to make that change within the Tennessee rules of categorization of the CPE courses.
You want to continue with, you want to stop there, and you want to continue with the full report so we don't, if we make a
I think I'd like to stop there.
That's fine.
And I'll second that motion.
We have a motion and a second on the floor.
May I clarify that that is those items, economic statistics and specialized knowledge to include the broker-dealers, et cetera, on the list, are termed to meet the relevant rule above that. That's the 0020-05-.03.
Yes, which is defined as the basic requirements for a technical course.
Correct.
Yes.
Thank you.
Thank you. Is there any further discussion on that motion? Hearing none, all in favor signify by saying aye. Aye. Opposed, like sign. The motion carries.
There was another category that was provided by staff that, in their analysis, that were subjects that Tennessee considers technical at the present time, but NASBA does not. And there are several of them listed here, and after review and analysis and discussion in the committee meeting yesterday, we recommend that two of those, well, first of all, there was a category called behavioral ethics broken out into this subject matter category, and the state of Tennessee has always considered all ethics as technical, and so we would recommend that they continue one category of ethics as opposed to two, and that all ethics be considered as a technical category. There was another, there were two other areas that are listed as technical. Marketing and IT, that we would recommend that they not be, marketing would be not technical and IT would be technical. Wendy Garland this morning informed me that one subject matter that we didn't discuss in the committee yesterday was IT, which we that definitely to be technical. So we didn't discuss that. Out of this listing on the bottom section here, the only one that we would want to move out of not technical would be marketing, which is not in agreement with NASBA, but we think it should categorize IT as technical. Is that correct, Wendy?
That's correct.
So I would make that in the form of a motion to relate to these bottom subjects, to make those two changes, leaving everything else as the way we're.
I'll second that.
We have a motion and a second on the floor. Further discussion? I did not see marketing listed here in this.
It wasn't, but it should have been on here yesterday. It should have been in the categorization. I think it was just
So I had created this, and I think I brought it up yesterday, that their marketing was, so on our sheets that we keep internally as to what's technical and non-technical, we had not been considering marketing as technical. However, ASBA advises me that at some point in time, they had it as though we were considering it technical. And so I just wanted to make sure that you all knew that and could clarify where you wanted it to land. So there was a discrepancy, really, between NASBA and our records as to what this board was considering marketing.
this sheet that we just passed out. It's under communications and marketing.
So this sheet is prior to us taking any action today?
Correct.
Okay.
So currently, what we've been discussing as marketing is non-technical for the board and NASBA? I mean, that's what this...
That's what this says, but NASBA's telling me that in their rule system, they have been coding it as technical for us. So I just want to make sure that you all would, I could have easily just said, no, that's not technical, change it. But I want to make sure that that's what you all wanted, because I don't know how it landed that way with NASBA. I don't know why they ever considered it technical, because our internal sheets, we don't have it as a technical subject. So I'm not sure how it landed there. So just want to clarify that it...
We just want to, today, to affirm that we want it to be categorized as non-technical for Tennessee.
For NASBA, it is non-technical.
Correct.
So the other change that we would have that currently IT is a new category that we would recommend.
What about economics?
That's in the first part.
Economics is in the first section that you just voted on.
Oh, okay.
So that is
Good.
something that we have not considered technical in the past, but you just voted to make it technical.
Perfect, okay.
So to clarify this, once all of the motion, assuming this motion passes and considering the one we've passed prior to this, the only difference we would have between what we consider technical and non-technical in NASBA would be business management and organization.
Correct.
Okay.
Behavioral ethics.
Maybe that is, we're saying that we would have one category of ethics.
Yes, I'm sorry, that is correct. That is correct. That would be the other difference, is we would consider all ethics technical,
Okay, and they don't, okay.
and they don't.
They have more than one category.
But you're following. Yay.
Another area that seems somewhat confusing is that there is a category of computer software and applications, and the NASBA elaborates about that. They consider application of software to be non-technical unless it has to do with the technical area. And then we now have a new area called information technology, which includes things like cloud computing. It just seems like perhaps those two areas at some points would overlap, and NASBA has clarified that, in fact, computer software and applications does go over into technical at some point. Maybe this is already defined and not a problem, but to me, when you say computer software and applications and IT just seems to be such a broad term that I thought we should clarify.
Very good. I'm not sure it's defined anywhere really except for in this type of document. I don't see that this board's ever defined it very specifically at all. So I would, if a licensee called me and said, this course is X, can I classify it here, I would probably refer to this fields of study document to kind of help guide us as to where it should fall.
Should we say information technology and have a parentheses excluding computer software and applications? Just to...
This is not published anywhere.
Okay.
So we use it internally to help guide us when we're talking to licensees and doing the audit and that type of thing.
So these last 3 items, specialized knowledge and applications that we currently say are non-technical, that and the statistics, we changed in that top group, right? Those 2 items? Okay. All right, so the only difference, as Stephen stated earlier, would be behavioral ethics and business management and organization. Everything else would remain, would be consistent with NASBA. Is that correct?
Correct.
Is that a motion?
We already had
Because I
a motion.
disagree on those
Second by the clerk to approve. Further point of discussion, and Karen brought this up this morning, which I thought was a very good point. We basically, with one exception now, it appears, are tracking exactly what NASBA is. And when somebody calls into this office to ask about one, they're referred to the NASBA classifications. And the idea was, and I thought it was a very good idea, that we may just want to say, since we are so closely aligned, we've documented, we've changed now, we may want to consider going forward with one that says, hey, we're going to track NASBA's list of, I mean, they're the ones that license the CPE providers, what classifications they fall under. They look at each course and say it's under the proper classifications. We may want to just say that we're taken out of the department for having to make a judgment call. How is it classified by NASBA, the one that approves all the CPE providers to start with on courses? I don't know whether any of y'all ever been through trying to get a course, actually gone through and filed the applications physically for a course, but it's fairly extensive with outlines and everything, and they approve the hours, they approve and each year you have to submit the whole outline again. It's not just a rubber stamp, although they have streamlined it some. So I think that is well worth considering here after we finish with this in the next area.
My motion is that we align with NASBA. That was my motion yesterday.
But the one's on the floor now is not that. So I'm just trying to, while we've got the floor up for discussion on it, you're the ones that are in the trenches over here helping us.
Do we have a second on that motion?
We do.
We have a second on
On making these changes here. The only difference after we make this change would be that the behavioral ethics is non-technical from NASBA, and we would continue it for technical.
No, and there's one more. The business management and organization. Those 2 are the only 2.
Okay, we call that technical.
Yes.
Okay. Thank you for the correction.
Oh, no problem.
Okay, we have a motion and a second on the floor to make that change here.
I just want to make clear, the motion that's on the table, the second is different than what you just...
His point of discussion on this was saying that we might want to consider something else.
Well, I'd like to say, I think I'm on board with Judy, that I agree with what you said, and I think there's a lot of merit to just lining up with NASBA. And I made the comment yesterday, I think they have lots of resources, and I do think they have CPAs involved in that. I mean, people that have actual practical experience and know what we do, and so I think they put a lot of effort and thought in approval of these courses, and I just think it would be best for us to totally align with that unless we've got a really good reason not to. And so just want to make that.
So I would like for everyone to reconsider, and I'm not sure what the process would be.
The process would be that we just withdraw the motion on this and then make a new motion if that's what the board wants to do. You know, the other thing that came up in this was that as we have mobility and our reciprocal licenses back and forth, you know, will our CPE that we approve qualify? I mean, it's going to hurt our member if they try to go to Kentucky and they've got a different CPE requirement to review their license, and we've classified something if it's not along with NASBA. So, I mean, it's not a big deal as far as aligning with them because we're so closely aligned after the work of this committee yesterday anyway. So
I'd like to restate yesterday what I said. If we don't go this direction, and we're using, NASBA's used this ideology that the difference between technical and non-technical is if it's used for your own use versus for a client. And I really honestly think that maybe they haven't considered it, maybe they have, but I go back to the educators taking tax courses or tax CPE. It's not being used for clients. And based on NASBA's ideology on this, then I think there's a strong argument that can be considered not to be technical.
Where did we hear that that's the ideology? I didn't see that anywhere.
This is just really under the business management and organization.
Right. Is there, did I miss that?
It doesn't refer to every type of so let me read you.
It was brought up pretty regularly yesterday that was the criteria of how they determine what technical versus non-technical was.
There's, obviously in our rule, we state management advisory services as something that's technical. So the NASBA breaks out into two categories. One category is business management and organization, and that is defined as something that focuses on management and administrative process of an organization, primarily a public accounting practice. So this is the MAP stuff that I think you all referred to yesterday. These are courses in time and billing, professional liability insurance, succession planning, usually directing the message to CPAs in the conduct of their own business. Then there's management services that focus on business processes of an entity, efficiencies, process improvements, identifying areas of risk. This area is usually directed to topics of how CPAs can assist their clients in their business processes. So that's how they have tried to separate it. Basically, they're saying time and billing, collection, succession planning, dealing with your own firm is something that would not be considered technical, but if you are taking something to help assist a client, then that would be considered technical.
I agree with Chairman Royston that if this creates a problem for our practitioners going anywhere else, it makes no sense in my mind to not just align with the NASBA classifications and just be done with it. I don't want to reinvent the wheel here. I don't want to second guess what's been done, but if they're the ones approving the CPE courses, they're the ones doing all the stuff, then we need to just align with, is my perspective.
They've defined these categories looking at accounting as the profession. So they're not saying that everyone who takes the CPE credits and is classified as technical or non-technical has to go through a test of whether it's technical for his or her practice. Is it technical in relation to this profession? So you can hold CPA certificate, of course, and not be engaged in public accounting, but I don't think that educators or people in corporate accounting or whatever would be in any different category because the reasoning is based on the profession of public accounting. That's how I understand it.
But I still think that a lot of these courses that you take for management accounting practices, a significant amount of the knowledge that you learn in that is considered technical knowledge because we use it for our clients. I've got law firm clients that use things that we do on a regular basis as a firm for their own practice, and that to me is clearly technical. I mean, I spend time on it, I bill for it, and I collect for it to tell them how we do it based on what I've learned in those types of classes. And I just don't see how anyone with a logical thought process could not consider that to be a technical subject.
I think there are pros and cons to going both ways because there's a huge advantage to taking the NASBA classification. But you're right, there are some people that will be left out, but am I correct that you can petition the board?
I was going to say, is there any provision whereby they can come petition this board if they disagree with the classification? And we can make exceptions to that, correct? So there is a fix to that problem if somebody wants to challenge it.
Okay.
You need to withdraw your motion, I think.
I'm perfectly willing to withdraw my motion to change it to say that we would align ourselves with NASBA's classifications in all of the CPE categories, period.
In that case, I second that motion.
I have a motion. Well, so we have to withdraw we withdrew the motions, we don't need to vote on it. So the new motion is to align with NASBA in all classifications.
I think I withdrew and added a new one at the same time.
And Ms. Weatherby has seconded it. Is there any further discussion? Hearing none, I would, all in favor signify by saying aye.
Aye.
Opposed, like sign. Aye. Motion carries. Good report. I think some great discussions, and that is a point that I would have to agree with you in principle. Maybe we need to run that up the pole to NASBA. And they can put... That's my point. Just because I think that's... But that's something that maybe they haven't considered, so... Does that complete your report, Mr. Elmer?
Yes.
Very good report, thank you.
Can we, I don't know what the protocol is, and I may be jumping in and speaking when I shouldn't, but how do we run this up the flagpole with them? Because I really think there should be more consideration in this subject. Now, if they tell me to shut up, that's fine.
Maybe just get you a contact person at NASBA to run that concern up.
They're very open, I think, to any kind of, I mean, it's not, I think you should, and I agree with you in a lot of aspects. I encourage you to take that step.
Would there be anything wrong with just letting Wendy have some dialogue with them and inform them of the robust discussion we've had here and
I think that's great.
back next meeting or something with some feedback? I mean, they can give us more insight. You as an individual having to figure out what the, line of communication is.
The benefit of being in Nashville is that NASBA's right here. So we could have Jessica LaCharles, she's the director of the registry, and she's the one I communicate with when I have questions about this. I think she'd be a great person we could invite to come talk to us a little bit about the process of determining these and what could be done about voicing our concerns. Sound like a plan?
Yeah.
Okay.
That's cool.
Noted. That's a very good idea, Wendy. Thank you. Law and Rules, Trey Watkins.
Yes, we had multiple rule changes yesterday that we considered. First one being that subsequent to our adoption of some new rules regarding the peer review submission, the AICPA weighed in with some commentary, and staff felt that those changes were warranted and were good changes. And so they have revised the rules to reflect those changes. What do we need to do? You said something about reading these in, or did you not say that?
Yeah, I'm going to let Liz describe what we need to do.
Okay.
I will read the rules into the records and also the government operations questions that need to be answered into the record as well. And after I finish reading those, we'll take a roll call vote from the board. There's two separate rule packages here, so I'll go through the first one, and then we can do a roll call vote, and then I'll read through the second one, and we can do another roll call vote.
Thank you.
I think we need a motion and second first. Correct.
Motion to accept the rules as proposed, or as what? What is the motion?
Is there a motion on the floor?
There is no.
No, there's no motion on the floor. We're trying to determine what this...
I'll read the first rule package and questions.
And then there should be a motion.
And then there'll be, one of you can do the motion to accept the rules as proposed, and then we'll take a roll call vote.
Got it.
You want to put the microphone down a little closer for your reading?
Thank you.
Since it's going to the record.
Thank you. As discussed yesterday in committee, our first rule package is the peer review submission, and this will be Rule 0020-06-.07 peer review submission. Firm shall submit a copy of the results of its most recently accepted peer review to the board. The required documents include peer review report, firm's letter of response if applicable, acceptance letter, letters accepting the document signed by the firm with the understanding that the firm agrees to take additional actions if applicable, and completion letter if applicable. 2, notwithstanding any provision of this rule to the contrary, for peer reviews scheduled on or after September 1st, 2017, all peer review documents referenced in paragraph 1 shall be made available to the board by the approved peer reviews program sponsoring organization via a secured website. The documents listed in paragraph 1A through 1C shall be submitted within 30 days after the date of the acceptance letter. If applicable, the letter in paragraph 1D shall be submitted within 30 days from the date the letter is signed by the firm. If applicable, the letter in paragraph 1E shall be submitted within 30 days of the date of the letter. 3, firms shall authorize a sponsoring organization to provide the board access to the documents in paragraph 1 via a secure website. Pursuant to Tennessee Code Annotated, Section 45401 through 45404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. Number 1, the type or types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. As of January 2017, the Tennessee State Board of Accountancy has 1,760 actively licensed CPA firms that will be substantially impacted by this rule. Under the newly passed peer review laws contained in Tennessee Code Annotated 62-1-201, these firms may be subject to disclosing peer review documents to the Tennessee State Board of Accountancy. Therefore, the majority of small business CPA firms will, through this new rule, 0020-06-.07, avoid the expense of producing paper documentation at the request of the Tennessee State Board of Accountancy, and rather will be able to utilize an online process for instant electronic submission of documents. Number 2, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. The new rule 0020-06-.07 mandates the use of an electronic process in disclosing peer-reviewed documents. Currently, the peer review provider utilized by the vast majority, if not all, firms in Tennessee already has such a process. This rule will require Tennessee firms to allow the provider to make available documents to the board through this process. Other than ensuring the firm has not opted out of the online service, no other cost outside of what is already in place will be required of small businesses. No professional skill will be necessary to implement this rule. 3, a statement of the probable effect on impacted small businesses and consumers. Small businesses will need to ensure their peer review program is making documents available on the peer review program's online process. This impact is less burdensome than the alternative of requiring the licensee to produce paper versions of the documentation. Outside of initial authorization, the peer review program will make the documentation requested in the rule available with no need for the licensee small businesses to perform any extra steps. Consumers will be positively impacted because this new rule will increase the board's ability to oversee peer review results in an effort to ensure peer reviews are conducted properly and to monitor licensees for potential violations. Consumers will benefit from the added accountability and oversight from the board. Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small business. The board believes that the rule is not burdensome, intrusive, or costly. Therefore, no alternatives are reasonably expected to be less burdensome. Number 5, a comparison of the proposed rule with any federal or state counterparts. There are no known federal or state counterparts to the rules. Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Exemption from Rule 0020-06-.07 would not be expected to be beneficial for small businesses because these rules simplify the peer review disclosure process by allowing the already existing peer review programs to ensure compliance through the already operational online process. Ultimately, this process will have a net positive gain, considering the alternative would be to require small businesses to produce physical copies of what can be voluminous documentation related to peer review process. Additionally, the peer review process and documentation is already being produced. This rule solely allows those documents to be shared with the board as allowed in Tennessee Code Annotated 62-1-201. And now I'll read the impact on local governments. Pursuant to Tennessee Code Annotated 45220 and 45228, any rule proposed to be promulgated shall state in a simple declarative sentence without additional comments on the merits of the policy of the rules or regulation whether the rule or regulation may have a projected impact on local governments. This proposed rule will not impact local governments. And additional information required by the Joint Government Operations Committee. A brief summary of the rule and a description of all relevant changes in previous regulations affected by such rule. Rule 0020-06-.07 was drafted in response to Tennessee Code Annotated 62-1-201, which grants rulemaking authority to the Tennessee State Board of Accountancy to promulgate the new rules for the administration of peer review results conducted on licensees. This rule specifically seeks to inform licensees which peer review documents must be submitted to the board, the time period for submission, and the process for submission. The rule also seeks to require both the CPA firms undergoing peer review as well as the peer review administrator to provide the required documents through an electronic process, commonly used in practice already. This rule will not change previous regulations because it is a new requirement and process not previously promulgated into rules. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal laws or regulations mandating promulgations of rules. TCA 62-1-201 in 2016 Public Chapter 595 mandates the promulgation of these rules in order to establish guidelines for peer review oversight and review. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. All licensed CPA firms will be impacted by this rule. It is unknown of their position. The organizations most affected by this rule are the AICPA and its state equivalent, the Tennessee Society of CPAs, or TSCPA. The TSCPA supports the adoption of this rule. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. No Attorney General and reporter or judicial ruling directly relate to the promulgation of these rules. Estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The fiscal impact of these rules is nominal. So at this time, the floor can be open for a motion.
Yes, I'd like to make a motion that we accept the rules as submitted.
Second. We have a motion and a second on the floor by the committee. We'd have to have a roll call vote, please. Any discussion? Roll call vote, please.
Pamela Church. Aye. Trey Watkins.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Stephen Eldridge. Janet Booker Davis. Aye. Gay Moon. Aye. Judy Weatherby. Aye. Larry Elmore.
Aye.
Kevin Monroe. Aye.
Motion carries. But we have another.
The next rule that we discussed was defining a license, so I'll send it back to Liz to.
Our next rule package, we actually have three rule changes. The first one was cleaning up the definition of expired license to reflect a rule change that the board previously made from 1 year to 6 months. The second rule in this second rule package was to clean up the definition of license to be more in line with the statutory definition of license, just to create consistency throughout the rules. And the third rule in the second rule package was to clean up the requirements for CPE hours that weren't already outlined in the CPA rule, and essentially to require the approval and submittal of the CPE hours and approval to be prior to attendance of the CPE course, and any courses after attendance will not be eligible to receive credit. So with that, I will read the rule changes into the record, and then I will once again read the government operations questions. Rule 0020-01-.01H, definitions is amended by submitting the following language so that as amended, the subparagraph shall read, expired license means a license that is more than 6 months past the expiration date of the license. Rule 0020-01-.01J, definitions, is amended by substituting the following language so that, as amended, the subparagraph shall read, license means a certificate issued under 62-1-107, a permit issued under 62-1-108, or a registration under 62-1-109, or in each case, a certificate, license, or permit issued under corresponding provisions of prior law. Rule 0020-05-.04, qualifying programs, is amended by substituting the following language so that, as amended, the subparagraph shall read, 9. In order to receive credit, any program of continuing education not specifically covered by this rule must be submitted to the board for an approval evaluation prior to attendance and/or completion of the course. A licensee, once per reporting period, may submit for approval up to 16 hours of CPE courses that are sponsored by organizations that are not registered with NASBA and are either offered on a limited basis or industry-specific. Any program submitted to the board after attendance and/or completion of the course will not be eligible to receive credit. Pursuant to Tennessee Code Annotated 45401 through 45404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. Number 1, the type or types of small businesses, and an identification and estimate of the number of small businesses subject to the proposed rule that would bear the cost of or directly benefit from the proposed rule. Rule 0020-01-.01H was drafted in response to the recent prior change to Rule 0020-01-.087, which reduced the time period for which a license is considered to be expired from 1 year to 6 months. The change here to Rule 0020-01-.01H should have been made when Rule 0020-01-.087 was altered. Small businesses will likely be unaffected by this rule change as it is being made to promote consistency throughout the rules and should have been altered along with the prior change. Excuse me. Rule 0020-01-.01J alters the definition of license to be more in line with the statutory definition. Small businesses will likely not bear the cost or directly benefit from the proposed rule. The changes to Rule 0020-05-.04 directly affect the licensee by restricting the manner by which CPE programs that fall outside of the normally accepted programs will be evaluated by the board. This rule is unlikely to bear a monetary burden or financial benefit to small businesses. Number 2, the projected reporting, record-keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record. Rule 0020-01-.01H was drafted in response to the recent prior change to Rule 0020-01-.087, which reduced the time period for which a licensee is considered to be expired from 1 year to 6 months. The change here to the rule should have been made when the previous rule was altered. The burden lies with the licensee to renew the license within 6 months past the expiration date. Rule 0020-01-.087. This rule will not require any additional costs or new skill of small businesses. Rule 0020-01-.01J will likely not require projected reporting, record keeping, or other administrative costs for compliance. This rule changes the definition of license to comply more strictly with the statute. Rule 0020-05-.04 will not affect the projected reporting, record keeping, and other administrative costs required for compliance. All licensees, regardless of whether or not they work for a small business, must be in compliance with CPE requirements. This rule only refers to the types of CPA courses that may be submitted for approval and when they must be submitted. It is required for all licensees to timely manage their CPE courses and corresponding approval. Number 3, a statement of the probable effect on impacted small businesses and consumers. Rule 0020-01-.018 was drafted in response to the recent prior rule change to 0020-01-.087, which reduced the time period for which a license is considered to be expired from 1 year to 6 months. The change here should have been made when Rule 0020-01-.087 was altered. This change is likely to reduce confusion among licensees about compliance with license renewals. Consumers are likely to be better protected from harm when licensees have renewed their license and are keeping up with the requirements to remain in good standing with their profession. Consumers and small businesses will likely benefit from the clarification of these rules. The changes to Rule 0020-01-.01J is likely to have no negative effect on small businesses and consumers. This change will promote consistency of license among the profession. The changes to Rule 0020-05-.04 could positively impact consumers because the rule will increase the board's ability to oversee CPE effort to ensure CPE credit is given properly and to monitor licensees for potential violations. CPE oversight is essential for making sure licensees are properly educated on changes to existing practice. Number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rule that may exist, and to what extent the alternative means might be less burdensome to small businesses. The board believes that Rules 0020-01.01H, 0020-01-.01J, and 0020-05-.04 are not burdensome, intrusive, or costly to small businesses. Therefore, no alternatives are reasonably expected to be less burdensome. Number 5, a comparison of the proposed rule with any federal or state counterparts. There are no known federal or state counterparts to the rules. Number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. Rule 0020-01-.01H was drafted in response to the recent prior rule change to Rule 0020-01-.087, which reduced the time period for which a licensee is considered to be expired from 1 year to 6 months. The rule change here should have been made when Rule 0020-01-.07 was altered. Exemption from this rule would not be expected to be beneficial for small businesses as it furthers the effort of Rule 0020-01-.087 by encouraging licensees to be in compliance with already existing license renewal process. Licensees should be held to the same renewal requirements. If licensees working for small businesses were given an exemption to this license renewal time period requirement, it would likely cause confusion among the licensee population. Exemption from Rule 0020-01-.01J would not be expected to be beneficial for small businesses, as it ensures that the definition of license is consistent with that mentioned in the statute. Exemption from Rule 0020-05-.04 would not be expected to be beneficial for small businesses, as it is imperative that all licensees, even those working for a small business, maintain their CPE hours. The amendments do not impose any new requirements on small businesses. The amendments only restrict when a licensee can submit CPE hours from sources that are currently not sanctioned by the board. CPE hours are vital in ensuring licensees are knowledgeable about the current trends and changes in the profession. Okay, I think I just have one more page to read. Impact on local governments. Pursuant to Tennessee Code Annotated 45220 and 45228, any rule proposed to be promulgated shall state in a simple declarative sentence without additional comments on the merits of the policy of the rules or regulation, whether the rule or regulation may have a projected impact on local governments. These proposed rules will not impact local governments. All agencies, upon filing the rule, must also submit the following pursuant to Tennessee Code Annotated 45226 I-1. A brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. Rule 0020-01-.01H was drafted in response to the recent prior change to Rule 0020-01-.087, which reduced the time period for which a license is considered to be expired from 1 year to 6 months. The change should have been made when Rule 0020-01-.087 was altered. Small businesses will likely be unaffected by this rule change. Rule 0020-01-.01H defines an expired license as one that is more than 6 months past the expiration date of the license. This rule previously defined an expired license as one that is more than 1 year past the expiration date. This rule will affect licensees by clearly defining the time by which they need to renew their license to remain in active status with the board and to correspond with prior changes to Rule 0020-01-.087. Rule 0020-01-.01J alters the definition of license to be consistent with that listed in the statute. This consistency will help eliminate confusion among licensees, as license is mentioned throughout the board's rules. Rule 0020-05-.04 adds restrictions on the manner in which a licensee can receive credit for CPA programs that are not already accounted for in this rule. This rule adds a deadline by which a licensee can receive credit for these programs. It also specifically states that programs submitted by licensees after attendance of the course will not be eligible to receive credit. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal laws or regulations mandating promulgations of these rules. Tennessee Code Annotated 621-105E authorizes the board to adopt rules in order to enforce the statutes of the Tennessee Accountancy Act of 1998. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether these entities urge adoption or rejection of this rule. Rule 0020-01-.01H and Rule 0020-01-.01J will impact all licensed CPAs. It is unknown of their position. Rule 0020-05-.04 will impact all licensed CPAs. It is also unknown of their position. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. No Attorney General and reporter or judicial ruling directly relate to the promulgation of these rules. Estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. The fiscal impact of these rules is nominal.
a point of clarification, rule number 0020-05-.04, you read into the record blue line 9, number 10, I don't believe was read in, and I believe that is to replace the entire paragraph, was what the rule change means, is the board specifically reserves the right to approve or disapprove credit for all continuing education claimed under this rule. Now, I'm looking at a printed copy that could have been changed, but
We are not making any changes to number 10 because we're changing 9 by essentially combining some of the information from 9 and 11, with some new additions. 10 will remain the same.
all right, but 11 is going away, and that was not noted. Is that, do we have to note that? I'm just trying to be sure before we vote that we don't have to come back and revisit it again.
I see what you're saying. Yes, so 9 and 11 have been striked according to the red line of the proposed rules.
And was too in the red line that I had.
No, you might
Do I put it on
I think
no
you have
copy?
the earliest version.
Okay.
And I
So it was not.
apologize.
Yeah, I'm sorry, I apologize.
So no, it's not a problem. I just want to clarify so we don't have to come back and visit again.
In the most recent version, and I apologize if that's not what you are looking at right now, in the most recent version, we've only striked out 9 and 11 and created a new 9, and
replaces
10
both of
remains
those.
the same, so that was...
And that was what was read into the record correctly, is the new 9 that replaces, just for the record, 9 and 11 are now combined into 9.
Yes, sir. And so 10 was not included in the most recent draft because 10 remains unaltered.
Us old folks still like printed papers.
I'm the same way. No iPad for me today.
That was my question, because I didn't see, it wasn't noted that 11 was struck from the record. I just,
When I read into the record, I only read the new rules. I didn't read what the old rule was into the record.
She's reading it as presented, as the new rule will stand.
well, I mean, if you're not addressing 11, then we need to at least say it was struck. That was my only question. I'm an attorney, so.
I think she's saying she's reading the rules that will stand, that will...
I'm sorry, I read the rule as it is proposed.
It isn't the complete rule, is it?
I just see what he's saying.
So 11's got to be taken out for it to be...
I see. It's,
She read with 11 out.
11 is right here in the rules as it is right now, okay? When you read in the new rule, you only read in a new number 9, and I think we understand it combines the other two, but that's not going to stay there because you didn't actually say into the record that was, number 11 was being removed.
Okay.
You may not have to, but we just don't want to visit
I'm
again.
sorry, I'm not sure that I needed to read that into the record. I understand what you're saying for clarification purposes, but essentially, I read Rule 0020-05-04, the new edits into the record, which is only number 9 now because 9 and 11 have been reworked.
But there's still an edit that 11 would be removed.
Yeah, that's what I was asking.
Not really sure what you're asking.
I'm just saying, we haven't changed number 11 based on what's been read into the record.
We haven't changed 11 based on what's been read into the record.
It still exists because we haven't changed it.
Okay.
We just want to clarify so it doesn't come back to
Sorry,
haunt us.
I was misunderstanding. For the record, to clarify, that they have to submit their CP.
Thank you for the clarification. Would you like to make a motion?
I'll make a motion that the rules be accepted as presented.
Second. We have a motion and a second on the floor. Let's have a roll call vote, please.
Emily Church. Aye. Trey Watkins.
Aye.
Casey Stewart.
Aye.
Don Royston.
Aye.
Stephen Eldridge.
Aye.
Janet Booker Davis. Aye. Gay Moon. Aye. Judy Weatherby. Aye. Larry Elmore.
Aye.
Kevin Monroe.
Okay, and then the final thing that our committee discussed, well, we didn't really discuss, we tabled for the next event, but asked that the board please review the proposed rule changes on fictitious names, and that Ms. Garvin was also going to get us the edits from Gabe. And so we will have that for a more meaningful discussion at the next meeting, because Gabe really wanted to be a part of that as well. So.
And then, board members, we also mentioned if we could get individual feedback from each of you on the proposed drafts, and then we could combine all of the individual feedback and send you kind of a list of what each board member was thinking for the fictitious names rule change.
Thank you. At this point, let's take a 10-minute break. It's 11:18. We'll be back by 10:18, excuse me, I'm on Eastern Standard. Let's be back by 10:30, please. All right. To reconvene the meeting, please. Our next committee report is Executive Committee, and Wendy, would you like to report for our committee, please?
Sure. I have the FY17 operating results. You should have this on your iPods named the same. In the first section here, I've just got, let's see, operating results and then the discrepancies. So far, year to date, we have collected just over $1 million at $1,002,930. This is a 2.4 increase over the same period last year, so we are doing well. The state regulatory fee, which is a certain amount of money charged on each license issued or renewed during the year, we have realized most of that expense. So less that $86,720, we are at net revenues of $916,210. On an expense side, we are, total expenses are $391,894, plus our preliminary cost backs at $144,000. Our total expenditures at $536,260, which leaves us net revenue to reserves $379,950 to date. This is as of February 28th, 17. So we have 4 remaining months in the fiscal year. We do not expect to have too much additional revenue because we are done with our renewal season. So with revenue at $8,000 to $10,000 per month, and expenditures running at $50,000 to $60,000 a month total, we should end up a little over $100,000 on the plus side to reserve. So I think 2 of the items I mentioned yesterday that we were just over budget slightly was longevity compensation, and we had retirement payouts for 2 staff members who left. In addition, when the state did performance reviews this year, raises went to all folks that received a valued classification. If you received a higher than valued, then you got a certain amount of a bonus, so that fell there as well. Under computer-related items, we are a bit over $3,000 over budget there. We had an expense related to our Zendesk platform, which is our customer service group uses in order to answer calls and track those tickets as they come in. So we were not prepared for that, but we will be going forward. I believe that concludes my report on financial.
Future statements, would it be possible just to take our budget for the remaining months of the fiscal year and just add it to the current P&L? In other words, if you've got your budget by month, just so we can kind of project where we're going to end at the end of the year. I'm not looking for anything fancy, I'm just saying if you could just take...
She has a monthly budget.
Do you do monthly? I can't remember.
I don't do it.
You don't do monthly, okay.
No, I get the numbers from our accounting director.
Okay. Let's scratch that. I mean, if there's no budget, it's...
She was about to assign it to your committee. That's a good thing.
Fictitious budgets.
I think you're in charge of the executive committee.
I'll point it to you.
A red line and a blue line.
Yeah, I'll try to think of a way just to...
I'm just not sure how he's, or who it is, I don't know who we're dealing with, but is it just an annual budget? Is that all it is?
Yeah, we have a spending plan, so that's what they call it internally. So when you all approve the budget, you're approving, for each line item, kind of what you want to spend where, and then that's just, we don't have a monthly budget, that's just, we're just trending along with that particular spending plan.
Thank you, Wendy.
I guess the bigger question is, we got these surpluses running, I don't know how we'll end up, but I presume we'll end up is, we've got a pretty hefty reserve balance, and
I think you had left the meeting yesterday when I brought up something that we're going to discuss in July that could have a substantial financial impact. We have a concern over, our rule states that if you're 65 and inactive, you
that's right.
shouldn't have to pay a renewal fee. So let's take a look at that and see, that way you all have a buffer to make whatever kind of decision you want. And then, depending on how you make that decision, we can see if there's anything we want to do going forward, and if we think we'll continue with these types of reserves.
Is there any reason not to have a large reserve, or?
Well, I think there's been potential for the state to come in and say, you're taking the money.
Two times in the past, if memory serves me correctly from my almost 9 years on the board, they have swept a significant, that's why we actually reduced our fees to our members, because we were being good stewards of our money, and trying to build like we've all been trained to be sure we're covered for a rainy day, but
I think we're approaching 1 year of operating expenses, and so it's time to say, well, do we really need any more than that, or what, should we do anything?
How much did we pay for that new computer system? That was $100,000, or was it more than that?
$75,000.
$75,000. We did that, and we still have this huge surplus.
I think we need to look at those kind of things, because I think you've mentioned from time to time that we have aging equipment and whatnot, so.
Yeah, and we also I had mentioned in one of my monthly reports that I emailed to you all, I'm not sure if you all read that, and it was not included in my current director's report, but we have been selected as a pilot board for the Alternative Work Solutions. That's a statewide initiative by the governor to allow people to work at home. It's actually a minimum of 3 days a week, and a couple of benefits of that, or reasons that they're doing that, is to help with being an employer of choice. They can't always pay what you can pay in the private sector, and so allowing people that flexibility is one benefit to employees. The second is to reduce the real estate footprint. If they're able to send 30% of the people in this building home, they can either rent out the space or combine buildings, those types of things. So our board is supposed to start in June, and we did have to order a significant amount of equipment for that. I have been told that is going to land not directly to this board, that's part of a pool that they've been given to implement this. So, but I don't, things.
What does that mean? We're putting workstations at home, or what?
So basically, we're re-equipping staff with a computer that could be used here and at home. So right now, they all have desktops.
But in the grand scheme of things, if we've got $1 million surplus, and you're talking if we spend $2,000 for one of our employees, then that's not a lot of money.
Yeah, no.
Yeah, and my guess is there'll be additional needs as well as that progresses, but
There may be. But I don't see, anything near
Oh, no.
$800,000 or $900,000, but, so we'll continue to keep an eye on it, and my other understanding is, so we used to have IT under the umbrella of Commerce and Insurance, and we were charged a certain way for those services. Those services have been centralized somehow, I don't know exactly, within state government, and they've been pulled outside of this department, so we are going to be charged differently for that. So knowing the outcome of that, we don't quite know that yet, but obviously it can't be as significant as our reserves.
So how does that work? I mean, it's somebody's always here, I presume.
From the Alternative Work Solutions?
Right.
Yes. So, well...
How do phone calls get answered? How does that...
You would not know. If you
It would just get routed to whoever
it gets routed to them at their home, right? So we are using some technology that allows for that. So when you call the number, you'll just get them there. As a licensee, you wouldn't know where they were.
Screaming kids and barking dogs, all that in the banging. That's what would happen at my house.
And we're piloting it for the rest of the regulatory boards. So if we have issues or problems, obviously they're going to be looking to us to provide input on how it's working and things that could be changed or modified. And
Are you apprehensive, or are you comfortable with it?
I am comfortable. We have a great staff that's very productive, and so I feel good about it. We also have a great way of tracking whether work's getting done, and we have a lot of metrics, so I feel good about that. It'll be helpful for our staff because we have one that commutes from Clarksville, one from Westmoreland, so I think it's going to be a benefit to them. So I am optimistic.
Okay.
I think overall, I think the point of it being getting more, you may attract, I think, more employees and maybe even more qualified employees and whatnot with that kind of flexibility. I think that's a very good thing, as long as you have those metrics and can monitor and make sure that everyone is productive in that situation.
This is going to be the standard going forward. I really do. I think it's true of all of us.
I think I would ask that you and the staff just brainstorm as to if there's anything that would radically improve your operations and efficiencies. If we have this kind of reserve and there's something that can make your jobs easier and that sort of thing, I would challenge you to be thinking about that, because rather than them sweeping this to get that money, I'd like to see it used to really boost the ability for oversight for the licensing and for the CPUs and whatever. Any way you can make things better. Just brainstorm about it. See if there's something that can be helpful.
I likes to talk about reduced fees, but that may be a place that we need to start looking as to renewal fees and things of that nature,
Right.
and saying, we're obviously collecting more than we use, not as a punishment for this group or this board, but obviously we're charging a fee that continues to build and accumulate, so maybe we need to reconsider fee structure.
I agree. I'd say in conjunction with the issue you noted yesterday about the over 65, I assume you'll have some recommendations on that, or some. But also, if there's just look and see if there's a way to cut fees and still maintain our good operations. I'd be interested in looking at that too.
Along those lines, Wendy, do you remember how long it's been since we last reduced the fee? I mean, we did that during Bill Balfour's term as chairman, I believe, didn't we? And it was not a huge reduction, but it was a reduction. Yeah. But isn't there also some requirement regarding not running a deficit for
Tony brought that yesterday.
2 years or something?
I think.
So we've got to be careful what we do there.
Right, you have to maintain self-sufficiency, and we don't have direct control over all of our costs. So about, a third of ours comes from the department. So that, as you all have seen, have been on the board for a while, that can be very variable. There's a lot of inconsistency there. So we have to keep that in mind.
to remember that our current good fortune or the year is affected by the fact that we cut out an investigator, in the last year.
Our case and complaint revenue is quite a bit higher too as well, and we don't typically like to count on anything there.
Even if we budgeted for a loss, we can't, so we're stuck with the reserve we have.
It's more than 2 years in a row, I thought, is what I heard Tony
That's
say.
correct.
Even
Correct.
if we budget for that, we can't. You can budget a loss, as my memory goes, but the 2 year of running in a deficit, unless you can explain it, then you can run into problems.
That's why I say brainstorm, see what we can do.
I'm not saying.
And just for informational purposes, the legal staff will still be in the building during the work days, so we are not doing the work from home, just in case you had any concerns for confidentiality purposes. I just wanted to let you know we will still be on the same floor in this building.
We will have documents, and we have with our investigator anyway, floating outside of the confines of this building that we need to be conscious of.
Yes, that's correct.
Thank you. Wendy, we got further?
Yes. Well, we did very briefly note travel. I think I had one trip on the Executive Directors Conference in March, and that was the only thing on the travel report. And then we also had a draft of a letter that the board asked me to prepare to send to the AICPA in response to the revised draft on the proposed evolution of peer review. You all reviewed that draft and approved it yesterday.
Thank you. Nothing further from the Executive Committee. Kevin Monroe.
Do you think we need a vote to approve that draft letter?
I think it couldn't hurt.
Okay.
Good point.
I'll make a motion that we accept the letter as presented.
I'll second that.
Any discussion on the motion? We have a motion on the floor. Hearing none, all in favor of approving the letter to the Beth Thornton, the Director of Peer Review Operations, the AICPA Peer Review Program, signify by saying aye. Aye. Opposed, like sign, motion carries. Kevin Monroe will handle our Enforcement Committee report today.
Thank you, Mr. Chairman. Yesterday afternoon, the Enforcement Committee met and reviewed each of the 28 cases where action is going to be recommended and subject to approval or disapproval by the board. Since I think all of the board members were present during those committee meetings, I'm not going to try to break down in detail each of these 28 cases. We've been through those yesterday. But I will kind of highlight and take them in batches to make sure that we have any comments or questions. So the first 7 cases in our revised docket that was given to us by General Counsel this morning are for recommended closures with no further action. There were no edits or changes that the committee members made to the recommendations on those 7 cases yesterday, and so we recommend that those be approved as drafted. The next category is letter of caution. That was case number 8. And again, the committee made no changes to the proposed recommendation, which was for this case to close upon issuance of a letter of caution. With respect to the next category of cases, which are recommended letters of warning, those would encompass cases numbers 9 through 14. The board did make one change with respect to clarifying some language that had to be removed, and that's marked in blue or stricken in blue in a revised packet. Some comments that were erroneously attributed to this case on number 9, but there was no change to the recommendation regarding closing upon issuance of a warning. Also in this batch, there's one case that I would propose that we break out separately, case number 11, because we have a board member that needs to recuse himself from that particular case. So we'll deal with that one separate when we get to the motions here. The next category is case numbers 15 through 26. These are case numbers where there is a recommended consent order in place. And I'll just briefly highlight the changes that were made. There were changes to two cases, 24 and 26, which are made in blue line. With respect to case number 24, the committee ultimately voted to modify the original recommendation and to recommend a payment of a civil penalty in the amount of $5,000 for unlicensed activity in that case. And then in case number 26, the Enforcement Committee ultimately recommended that there would need to be a formal hearing for the maximum penalty with authority to settle via consent order upon respondent's payment of a civil penalty in the amount of $3,000 for failing to be enrolled in peer review. So that would cover those items that would be in the consent order category. And then finally, we had two remaining cases in the representation category, cases numbers 27 and 28. And with respect to case number 28, the committee yesterday adopted a modification from the original recommendation so that the new recommendation that has been recommended by the Enforcement Committee for the board's consideration is to deny the respondent's request for an informal meeting and proceed to a formal hearing. And so that summarizes the work and ultimate recommendations of the Enforcement Committee. And with the chairman's permission, I would move that we accept the recommendations for all cases except case number 11, which we will deal with separately to allow a board member to recuse himself.
Motion on the floor. Do I have a second?
Second.
Have a second? Any discussion on the motions? Hearing none, all in favor signify by saying aye. Aye. Opposed, like sign.
That we approve the recommendation with respect to case number 11.
I'm recusing myself from number 11. That's true.
Motion on the floor. Do I have a second?
Second.
Have a second. Let the record show Mr. Watkins is recusing himself from the vote. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Good, clean report.
Well, thank you, and particularly thanks to the legal staff for laying this out and working through us in committee yesterday. That was much appreciated.
At least an hour shorter than yesterday's report. Legislative update, please. Is there any to report?
We just have a few bills to briefly discuss for the legislative update. The first one is House Bill 0326 and Senate Bill 1217. And this bill basically requires boards when they're, I'm sorry, I think I was talking about another one. Let me start with House Bill 0566/ Senate Bill 0449. This bill basically requires boards to promulgate rules if they're going to establish guidelines to practice that they've adopted from national organizations. For example, if you wanted to adopt NASBA's ethical code, you would need to do so through rulemaking. Essentially, you can, with this bill, you can keep whatever you have now, but if you were to change, say you wanted to adopt the most recent guidelines, or say they produced guidelines from this year that were different from last year, and your rules currently refer to the last year's rules, and you want to make sure you're up to date, we would just need to do so through rulemaking. So this bill has been passed, and we will give you more information on how that will be implemented as it affects the board. Referring next to the one listed up top, House Bill 0326 and Senate Bill 1217. This is authorization of a chief executive officer or commissioner which oversee the regulatory boards to have the authority to approve or veto rules and actions that may constitute unreasonable restraints of trade on licensees by the board. And this bill has been passed as amended, and has been transferred for the governor for implementation action. And as of right now, we do not know specifically how this bill is going to be implemented, but we will update the board as soon as we hear about that as well. Moving next to House Bill 0775, Senate Bill 1083. This was a task force that was created to kind of oversee regulatory fees. Their goal is to eliminate some unnecessary fees. So earlier when you were talking about whether or not you could create a reduced fee, even if it was just by a small amount, those are the things that the task force will be looking for. And this bill's current status is that it's been transferred to the subcommittee of the Senate Government Operations. And then you'll see several bills listed that addressed reducing or eliminating the professional privilege tax. There was different variations of this rule. Some of them reduced it altogether immediately. Some of them reduced it gradually over a few years. Unfortunately, none of those rules seem to be making any headway and have kind of all been set on the back burner for further research. So it doesn't seem like any action is going to be taken with any of those, at least not during this this session. So that concludes the legislative update as of now.
If the professional privilege tax was reduced, would the business taxes come into play for those who previously paid the professional privilege tax? Or do you
I know you previously asked that question, and I have not thought about it again to try to inquire, so I'm not sure, Janet. I'll try to remember to ask somebody at some point.
Further questions? Thank you for a good report. Under old business, Accountancy Licensing Database, Disciplinary Data, the ALD. Wendy, would you bring us up to date on that and what we voted to do? And I believe you have a matrix for us or whatever.
Yes, sir. On your laptop and in your documents, you have a document titled ALD Disciplinary Data. So, if you all will recall, at the last meeting, we had Maria Caldwell and Stacy Grooms from NASBA join us to explain the request that we've talked about, I guess, for 2 meetings, to feed our discipline over to the national database of licensees, the Accountancy Licensing Database. So there's a private side which is used by boards, so that we can share with each other across the country where everyone's licensed, are those licenses active, etc. Most states, I think there's an exception of maybe 5 to 10 that do not feed that discipline, or I'm sorry, that feed, everyone feeds over general information, and what we're being asked to do is add disciplinary records to that feed. And we discussed extensively, I think, at the last meeting, this particular request and some concerns about doing that. Ultimately, the board voted 9-2 to move forward with this process and asked staff to bring back to you some more specifics on what violations would be flagged in the ALD. I'll step back for a second. Part of this request came as a result of some legislative action in California to allow for mobility. So just to remember that part of it. The document that you have clarifies what California's requirement is in order to obtain mobility within that jurisdiction. So their practice privilege form statement regarding your type of discipline that would be included as something you would need to report to the board if you wanted to practice there would include any practice violations and also administrative actions that were resulted in a restriction or penalty being placed on any professional license you have or have possessed, such as revocation, suspension, probation. It does not include other types of administrative actions such as citations, fines, orders of abatement, or orders to take specific continuing education courses. So what I've done in this document is I've taken the violations that would require a flag, they're considered practice violations, or they change the nature of or the status of your license, and I've put those in category 1. So those would receive a flag, and we would be in compliance with California, and our licensees would be able to practice under mobility there. The second category is the type of violations that wouldn't necessarily need a flag to meet their requirements. I've been advised that most states do include a flag for these items, but this is where the board might want to make a decision one way or the other. And then, of course, nothing, if the person is unlicensed, there is no, they're not in the database. So that would be kind of a third category that I didn't really mention here. So, so that's the information I have. Are there questions or suggestions?
Or do these flags stay with you forever?
My understanding that it remains, just like our discipline. If anyone calls and says, does Stephen Eldridge have any discipline against him, I would have to look at your entire file.
Isn't there a procedure in the legal side where people can get their things expunged from the record? I'm just saying in general.
In criminal cases, yes, but not in our administrative procedures.
Is our website, is it permanent?
Yes. Well, it goes back
Till it was created.
till it was created, yeah.
You didn't go back and put in the historical stuff, or they did, not you, but whoever.
Right, so the website goes back, I don't know, 10 years or so, and then, but if you call the office, we would provide anything from.
It's just my only hang-up is it's something that carries with somebody forever. I mean, everybody's going to make a mistake. I mean, it sounds like we have no opportunity for forgiveness and forgetting.
Well, you would have, you could kind of come to a consensus with this and potentially not flag those items under number 2 if you wanted. Those are, I think, less serious. The ones in the first one are pretty serious violations. So some of the ones in the second category are kind of a non-renewal, maybe a CPE issue, something like that. Then in the category 1, I mean, we're talking about code of conduct violations.
I guess I'd ask the question, I want to make sure we're doing this because it's a good practice and we're not doing it simply because California has issued some kind of ultimatum to us. If we don't do this, they're not going to, it may affect our reciprocity with them. And that's the issue I have, because quite honestly, I don't care what they do. We're doing what's best for our practitioners, not California practitioners.
I would agree with that. I think we had that discussion last time, and that this is the uniform practice by all states reporting in the ALB, and with mobility, that it becomes more important to us even relying on the ALB reports. When we want to look or somebody asks, we can pull those up. There's always the option, like Wendy said, to call the board. And I think as long as we note that somewhere on our website or whatever, that
They won't have to call the board now.
well, but they would, because if you, and I spent a long time on the ALB myself, I got okay to get a little code to get into it, and it does not, except in extreme cases, tell you a whole lot except they were disciplined for this. It doesn't go into the details of any case. So if you have a question, you're going to call the board if you're looking to hire somebody or bring somebody up and say, well, what did this entail?
How much do you give out when people call? Do you give them the full case? I mean, do you give them the full?
Not give the full case. Typically what would happen is the consent order, if there was one, or final order would be requested from legal. They would review it and redact any personal information and forward that.
Yeah, I don't want to rehash this because I've obviously got an opinion on this, but it's a blacklist, in my opinion, for future employers. And
Does the date of the infraction show? Yes. You can tell if it was 10 years.
You can tell if it was 10 years ago or whatever. It says they're flagged, and then you can dig a little deeper into the ALB, and it tells you the dates of the infractions or whatever. And obviously, if they're still practicing, and this was 10 years ago, then they paid their penalties and moved forward. So.
how would that work? Would it just be cases that go forward that we're going to put on here, or are you going back and historically dumping information into the system?
I am not positive.
am not positive. I do
That could be a
believe-
massive
I do believe that they were going to go back a short period of time, but definitely not everything.
Oh, you can do a
I
data
think they
dump
were going to
on
basically go based on what was easily accessible on our website.
website and dump it.
And the NASBA officials said they would work with us to try to facilitate that, which I appreciated.
That opened up some issues with somebody that would say, I've had a complaint this year. Well, it's not fair that somebody had one 5 years ago. It's not going to ever carry with them, but mine's going to carry with me for my life. I mean, does that create an issue there?
We got that issue on our own website.
I mean, that's going to be the case in Tennessee. I mean, it's out there in Tennessee, and it has been. So the question is it going to be through this network informing of other state boards, I guess, or other participants that are accessing this website? I mean, I hear the concern. I don't like to dance to the state of California's drum on most, if not everything. But at the same time, mobility is critically important, and also knowing and upholding the standards of the profession. And at this point, if we went with just Category 1, I mean, I don't really have an argument with that, but I would be very comfortable not submitting Category 2 forward. And that was kind of what I thought in my mind when I said we would minimally comply, that we would put in what we had to put in.
Category 1's like your revoked license status. That to me is kind of things that are on that list that we would probably take away the license of the practitioner.
And you'd want to know if you were going to hire that person.
And if number 2 became a problem, to where we took that license away, that would move to the other category, and then if the minor infractions were fixed, there's no need to report. So I think y'all done a super job in coming up with this list, personally.
I have a quick question. Are there any other, do you have knowledge, it seemed like in my memory, we were like one of the only states that weren't doing this kind of thing?
There's 5 to 10 states, if I recall correctly, that aren't physically feeding the data over, but she's telling me we're the only one that hasn't authorized it. So the others are just more hung up on technology issues.
Oh, okay.
But she's telling me that we're the only board saying that we don't want to move forward at this point.
Well, we've said we're going to move forward at our last meeting, but it's a question of implementing.
Right.
We need to approve this list, recommend.
Well, you can do one of two things. You got to include the second group, whether or not you want to do that.
Presented levels 1 and 2.
Right.
I would offer, I don't want to cut discussion, I was going to offer up a motion, but go ahead.
I just noticed that the recommendation, there's a recommendation at the bottom of this, and I don't know is that what we came up with at the last meeting, or is that your...
That was just my recommendation.
Okay.
That's how I feel. Y'all can vote
Okay.
however you want. That's my recommendation.
Will it indicate what these items are, or is it just going to have a flag?
I think it's just a flag.
Okay.
Or does it give you do you recall?
Once you upload the data in the disciplinary action, then the flag dumps you down to I believe, to what the infraction was, when it occurred.
Another tab, and right now I see varying things from other states. Sometimes it's just there's been discipline, call the board, and sometimes it's very minimal violation listed. So almost in all cases, I would call the board to get more information.
It's not uniform by any means.
Okay.
Yeah.
So would a reader of the ALD site be able to tell that we weren't including Category 2 here in our flags?
Not going to be reported.
No, we're just not reporting. It's not reported as far on the list. As far as we're concerned.
Those people would be on our website. So we report all discipline on our website.
Well, how often you get a call, or does this board get a call for someone calling in and saying, can you give me a list of everybody in the 38305 area code or whatever area code that has a disciplinary action on the record?
I've not had that request since I've been here.
And now this gives them easy access to be able to search by areas. I'm sure there's some kind of search criteria, or is it just name?
Search criteria is by name and by state.
Say it again.
The search criteria is by name or by state. I don't think you can search by zip code in the ALD.
So do you get a lot of questions when people calling in and checking on licenses?
We occasionally get some, but it's, maybe a couple a month, if that. And typically, it's another board asking because they've come upon some indication and need some more information.
Further discussion, you want to entertain a motion?
Would offer a motion to proceed with including the violations listed in Category 1 in the ALD programming process.
Second that motion.
Have a motion and a second on the floor. Is there any further discussion? All in favor signify by saying aye. Aye. Opposed, like sign?
Aye.
Aye.
That was Stephen, Trey, and Larry.
Motion carries. Do we want to do anything or just remain silent on the no flags? For your purposes, do we want to prove that these are non-reportable flags?
I think maybe that's a Liz question.
So the last vote was to approve the items in Category 1 to be fed and flagged as discipline in the ALD. Do they need to make a particular,
Authorizing what you can put in there.
Do they
have to authorize what wouldn't go there?
I would.
So a motion that the
Items in 2 would not be reported.
I would make the motion that the items, we do not include the items in as Category 2 in the report, the ALD report.
Second thought. We have a motion and a second on the floor. We are not including number 2.
Category 2, we're saying we're not going to include those.
But that's what the last vote was.
That's to include number 1. Category 1.
But now they're saying we
I
need
voted no because I think if we're going to include anything, we should do both. So I didn't mean to vote. I wasn't opposed to one, I was just opposed to not putting both.
You misvoted, Dan Larry.
I'm sorry.
Yeah, you can't take it back now.
We have a motion to approve number 2 with a proper second, and to include in our list of things not reportable, the items in category number 2. All right, is there any further discussion? All in favor signify by saying aye. Aye. Opposed, like sign. You got 2 no's out of that one, didn't you?
Can I amend my vote on the last one? Because I'm for it, including ones.
It passed, just so you know.
He doesn't want to.
If we want to withdraw the first vote.
Yeah, just for the record, I'll
Okay, for the record,
Before you were against it, is that how it works?
with the clarification of the previous vote to include category 1, we are withdrawing officially the formal vote on that, and we'll re-vote on including the motion to include category 1, properly motioned and seconded on the ALD feed, those items in category 1. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Aye. 2. Motion carries. Re-carries. Okay, Wendy, I think we have it to Tennessee state specifics. State-specific ethics.
Can we pause for a minute? Karen is having trouble making sure she got that correctly.
Stephen and I were the only no's on that one.
Right. So I think what she's asking is, did we vote to remove the initial
Yes.
vote? Yes.
We voted to move the initial vote.
Okay.
and to replace it with a vote to include every
And number 1 in the ALD feed, and they re-voted, and the nays were Trey and Stephen. And I think we were also unclear on the vote from the category 2. The vote was to not include those items in the ALD, and we had a couple of nay votes. Oh, we just had 1. Okay, Larry. All right. Does that
You
happen?
no? No, you were not no. Okay.
Thank you. Would you bring us up to date on our Tennessee state-specific ethics, please, Wendy?
Sure. Okay, at the last meeting we had, well, for a couple of years, we've had extensive conversation about our state-specific ethics program and process in which we approve multiple groups to provide the state-specific ethics course. Due to inconsistencies, inaccuracies, over the years, there have been a lot of conversations about what can we do to improve this process. So at the last meeting, the board voted to authorize TSCPA to create and deliver a program for CPAs across the state. They would offer it, they would offer the course, and then they would also offer it to sponsors who could buy those materials from them and then offer that themselves as long as they were approved through us. So, since that meeting, Liz and Tony and I have met with our contracts attorney a couple of times, explained the situation. They have advised that we would go through what we call a memorandum of understanding process. So we would create that agreement with TSCPA. And basically that agreement would outline their responsibilities as well as our responsibilities in providing this course. And really what we're doing here is we're making sure that if this is the only course that you all end up approving going forward, that it will be there for our licensees. So we want to make sure there is something for our licensees to take that meets the requirement. So this helps ensure that both parties know what they're going to do and that there will be a program there. Should we, down the road, you choose not to approve any other courses, okay?
And part of the reason why we didn't go with the contract route is because we had, our contracts attorney told us that there was several issues that would pop up doing a sole source contract, and that central processing would have to approve the contracts, and that typically in the past they've been inconsistent with the contracts of the nature that we would need. She also mentioned that the RFQ or RFP process, if you did open up to other providers being able to bid for the contract, would take a long period of time, and we wanted to make sure that we implemented this before the expiration date came up at the end of December.
In addition, I think that there was a comment about should this get through the even if that RFP got through all the way through the process, it may be determined that our rules are not set up to contract on a sole sourcing ability. So what the memorandum does is it creates an agreement with TSCPA that they will provide the course and materials for a period of time. Now, if other courses come before you, you have every right to just deny those due to your concerns over consistency, quality, inaccuracies that you have noted in the past, and that is on the record in almost every meeting we've had. The memorandum of understanding has been drafted. It has been shared with TSCPA. They have one bullet point that they're trying to do a little more research on. It has to do with their pricing strategy and that type of thing. It doesn't go into a lot of detail, but they just want to be comfortable with how that's worded, and they wanted a couple more weeks to do some work on that. So I don't have that ready for you to review and approve today, but I see no reason why we wouldn't have that finalized at the July meeting. Does that make sense?
Further questions regarding that? Thank you, Wendy. I think the dead horse has already been talked about the fictitious names and clarification report that's on here. Well, it's a wounded horse at this point, but we've talked about it enough, and I guess you'll have it at the next meeting. Well, my crippled founder. Anything further to report today?
I have a couple of things under new business. First, to let everybody know, we'll be doing officer elections at the next meeting, so just keep that in mind. And I did not report, because it just happened earlier this week, but I did get approval from the Department of Human Resources on the hiring of our investigator that you all approved a couple of weeks ago. She has been offered the job, she has accepted, and will start on May 22nd, so she will be at the next meeting. And then I do think that we have one other thing that we would like to address with the board. Casey, if you wouldn't mind.
Yeah, this is Don's last meeting with the board, unless for some reason the governor doesn't appoint your successor. You notice I didn't say replacement, you can't be replaced.
That's right.
But thank you. We understand the governor's office is working feverishly on that, so you don't have to come back. We really want to thank you for your service on the board. I believe you have a plaque that we're going to present you with, but before I do that, I would like to just tell the rest of the board, I have known Don Royston for more than 30 years, and significantly more than 30 years, but Don has been a partner, a leader in one of the, I think, best and most respected accounting firms in the state of Tennessee, particularly in the Kingsport, Tri-Cities area. I know that Don and his firm had a strong commitment of giving back to the community and giving to the profession, and I know that Don has demonstrated that. I don't know a lot of specifics about your community service, but I know that Don served as president of the TSCPA, our state organization, and one we just talked about here. He has demonstrated a strong commitment through the Education and Memorial Foundation, which is the arm of the TSCPA that funds scholarships for deserving accounting students. And I know that he personally has put a lot of time and money and effort into that process. But what we want to do today really is thank you for your approximately 9 years of service here on the board, and your insight, your comments, and just really your total contribution, Don, and particularly the last 2 years as serving as chairman of the board. But I had hoped we could give you and your family an all expense paid cruise or something, but Wendy tells me that's not going to happen. So we do have a plaque here to present you with, and I want to just read this. It says, presented to C. Don Royston in recognition of and appreciation for your significant contribution and leadership to the CPA profession. Tennessee State Board of Accountancy, 2009 through 2017. So with that, Don, I want to just say thank you. I would encourage anybody else that wants to make comments to do so, but if you don't do that, come and shake his hand and wish him well on his way home. So thanks, Don.
Thank you for the kind comments. I can tell you that this has been I've been the winner, and I think each of you and around the room would agree that when you serve on a board like this, you develop friendships. It challenges you to be a better practitioner. And I'm so thrilled that this board looks out for the practitioners, and we have never, since I've been on the board, tried to be the policeman that goes out and just swings the hammer without thoroughly investigating. I know we have let people, I'll say let them off because we didn't have a proper case, and we knew that it was just a weak case because we wanted to give them the benefit of the doubt. And I would encourage each one of you to do that, and I thank you for everybody's time, and particularly the wonderful staff and the administration that we have now. It's just over the approximately 9 years I've been on, and that approximates because I filled the unexpired term after, I think, one meeting of someone that got off the board and moved or something early on, so I didn't have quite the full 3 terms, but thank you all for your support and dedication, and I think Casey's running for president next time. I would endorse him after those kind of comments.
I would just like to say it's been an absolute pleasure serving with you, and your great leadership has been, it's just been awesome to be on the board with you. And deserve a lot of credit for helping develop. I think we have just an A-list group of people here, and I think our staff is top-notch, and I am very proud to be a part and honored to serve with you on this board.
I can say that there's no fiercer defender of the profession than you, and I've come to really appreciate that in you over the past several years. Your leadership has been just great, and we've had a lot of ups and downs on this board over the past several years, and you've been right there, rock solid the whole way through, and we really do appreciate your leadership. Thank you, Trey. Yeah.
Do we have any money in the budget to take them to lunch or anything?
When they bring lunch in, we have to pay for it.
I just want to say, I think I've served with you for going on 6 years now, and I think your gift of discernment and you seem to create clarity in a lot of foggy situations, and I know we've been through a lot of tough issues, and I just respect and appreciate your leadership and helping mentor me a little bit as I came in blind and didn't know what to do. And I remember the night before my first meeting, I couldn't sleep because I thought, oh, man, what am I going to do? I'm lost for words, and that doesn't happen very often. And I met Don, and matter of fact, I remember that first day, I didn't realize that you couldn't get change in here in this building. You had to walk 6 miles down the road in the snow and ice. And it was like, here you go, I got that. So I appreciate it. I know, but I appreciate that. Thank you. You'd like to get that back today, by the way. I know. Thank you all. Is there anything further to come? Could I do a pro bono or just really bizarre? Commissioner, fictitious things.
I would say, I don't know if I can say anything further than what everybody else has said about Don, but I would say that a lot of his great qualities came from his dad, who was also very active in the profession. So
I thank you for recognizing that, and I'll selfishly agree with you. And I was mentored long before I got on the board by someone that has also mentored Larry, Mr. Will Pugh, that's kind of like a cornerstone or pillar out here on this of the previous state boards. Anytime I had a question, I could call Will. Still today I can. And I would just say, if there's ever a question that you can discuss outside the board, I'm no longer on the board, will no longer be on the board, so I can discuss anything. So.
From a new board member's perspective, I certainly have appreciated just seeing you in action, your sense of fairness, and particularly when we have hearings or we're trying to deal with a difficult disciplinary matter, your care for them as well as the people that they affect. And your welcoming nature to all of us, so it's greatly appreciated, and it's been an honor to serve.
I would echo that. I had a fear when I started this year. I thought, well, what's it going to be like? You know, is the town going to be gotcha? You know, we're going to be extremely strict, and it's been wonderful to see the care, the tone that you've set, and the care that you show for the individuals, both the ones in the profession and the people they serve.
I want to thank you. It has truly been an honor. Your consistency and professionalism has been a great source of encouragement for me, and I think for all the CPAs. So thank you.
Thank you each for your kind comments and surrounding yourself with consistent, helpful staff. I mean, this team over here, as you all have noted, Wendy feeds it. She calls me, and I've tried not to burden her by having a weekly call with her. I just don't think it's necessary. If I see something come up, I send her an email, and that's it. And, have a great team, so thank you.
I don't think I've met a more gracious person, so I echo what everyone else has said, and no one will make you feel more comfortable than Don. So you've been a pleasure to work with in the past 2 years and longer.
And do I get this again if he doesn't appoint somebody and I come back?
Yeah, we're going to have to do this all over again.
Take back all your comments.
We can do lunch.
And Don, I don't want you to think I don't like you, so. I'm proud of you, lady. I know, but yes, thank you so much. And just thank everybody else. So, anything else to come before the board today?
Let's just get a picture with your
Okay.
But we can adjourn first.
We will adjourn, and Casey and I guess will stand with the seal behind us, I guess, up there. Okay.
All right, thank you.
Meeting's adjourned.
Good luck this year.